This is Michael Popok, Legal AF. Every day, Donald Trump and his lawyers and his lackeys try to float new defenses to the criminal prosecution of Donald Trump down in Miami on Mar-a-Lago. There's 4 major ones. I've heard them all. I've looked at them all. And I'm here to tell you that they're all dead bang losers. Let's go over them one at a time, plus new information I picked up concerning Donald Trump's likely witnesses against him. Evan Corcoran, his former lawyer. Let's start with defense number 1. You'll hear a lot about it. It works in rallies. It works in Cuban cafes in Miami. It doesn't work in a court of law. And that is the Presidential Records Act allows Donald Trump to magically designate what is personal records and what is presidential records. And he's a very busy man. And he just didn't get around to doing it. And therefore, the whole search warrant subpoena process was flawed, and all of that should be in his favor. That's all a lie. I mean, let me just call it out. I know that on other mainstream media channels, they like to pussyfoot around about calling something what it is, but not on the MeidasTouch network. The Presidential Records Act is not, there's no good faith interpretation of it or construction of it that fits with Donald Trump's defense. Not one bit of it. The act says that everything that goes to the operation of being the president of the United States, anything that goes to being the job function, responsibilities, constitutional duties, those are, by their very nature, presidential records, therefore the people's documents, and need to be returned upon the end of the office to have them properly archived by the National and Presidential Archivist as the Presidential Archive. That's it, plain and simple. Any other argument that you've heard about he's saved somehow, or the Presidential Record Act will be a defense and the jury will be so instructed, is a lie. The Presidential Records Act does not give him a defense to the Espionage Act violations, the acts of obstruction, the acts of interference, the acts of hiding documents, the acts of lying to his lawyers, the Department of Justice and the FBI, and ultimately to federal judges that led to the ultimate execution of the search warrant. And even since the execution of the search warrant, let's be clear. Donald Trump has had almost a year since the execution of the search warrant to either work out a deal with the Department of Justice, go back through his documents, return the presidential papers, and beg for forgiveness. He hasn't done it. He's never done it. That's why there was an execution of a search warrant in August of last year. That's why he was indicted last week for his own misconduct. He likes to say in his rallies, this is a sad day for democracy, a sad day for justice. It isn't. It shows the justice system works, and that if you commit crimes, you're not going to be given a pass just because you were the former president. That's not how that works. So let's take off the board the Presidential Records Act defense, because everything that we're talking about, those hundreds and hundreds of national defense information documents, some marked top secret and classified, go to his constitutional and other duties as president and needed to be returned. Full stop, period, end of story. So now let's move on to the Espionage Act. The second defense you're going to hear or have heard from Donald Trump at rallies and after he left the arraignment is that the Espionage Act isn't being properly applied to him because he's not a spy. Or, he wasn't spying for another country. That is a complete misrepresentation of the substance of that statute. Yes, it has a very sexy name, Espionage Act. Sounds like double agents and triple agents and people wearing, all sorts of raincoats and hats and okay, but that's not what it applies to. It applies to anyone who willfully withholds national defense information material. That's it. It's not yours. It is NDI, National Defense Information. You don't return it. You've just committed a violation of the Espionage Act. And whether you were going to do it for transactional purposes, because you were going to trade it for something with one of our allies or enemies, or you were just going to use it for the future transactional use, doesn't matter. That's not the criminal intent that's required for the violation of the Espionage Act. It's only that you've willfully, meaning it wasn't accidental. That's what willful generally means in the law. Intentional acts. And everything that's listed in the indictment, and so much more we haven't even heard about yet when this case goes to trial, in terms of the evidence, mountain of evidence the Department of Justice and Jack Smith have, indicates willfulness and intent, not accidental. He wasn't the accidental espionage violator. Donald Trump was the intentional and willful Espionage Act violator. If you take one thing away from the indictment, it's how involved personally Donald Trump was in hiding and secreting documents from the National Archive, then the FBI, then the Department of Justice, then his own lawyers, then federal judges. Period. He selected what boxes would go back to the National Archive personally after reviewing them. He gave instructions to his lawyers to not be truthful to the National Archive, to not be truthful to the FBI. He, when he wasn't sure if they would do the right thing, Donald Trump made the decision which boxes to put in the storage room in Mar-a-Lago for his lawyer to look at a week later and which ones to leave out, and then move boxes in and out of that room after the lawyer had left under his own video cameras before the Department of Justice arrived. That was Donald Trump's decision-making. It wasn't he had lackeys and buffers reviewing the boxes. He would have dozens and dozens of boxes delivered through Walt Nauta and other people up to his personal residence at Mar-a-Lago, where he personally reviewed them. Period. That's your takeaway from the indictment. And everything I just talked about, instructing his lawyers to lie to the National Archive, instructing his lawyers to lie about documents that existed but he didn't want turned over, making them lie on forms that they had done their due diligence to look for documents, hiding the documents, moving them from Mar-a-Lago within Mar-a-Lago, moving them away from his lawyer so he wouldn't see them, moving them to Bedminster. Those are all badges of intent. Those are all willfulness. That is what the criminal statute requires and nothing more. He is reading in and telling his gullible followers and those that want to push back and go after the Biden crime family, talk about projection, that he didn't commit espionage because he's not a double agent. He's not a spy. This isn't Boris and Natasha. This isn't Rocky and Bullwinkle. That's not what the statute says. All you have to do is you have to have them in your possession. And even if you don't use them for any purpose, the fact that you have them in a box, 1 box, 15 boxes, 20 boxes, whether they're mixed in with your personal dirty t-shirts and shoes or whatever you're claiming or not, you've committed an act of to violate the Espionage Act. No different than, Teixeira, the National Guardsman intelligence officer, who did the same thing and is now subject to 16-count felony indictment for violations of the Espionage Act. Let's go to this. Take that off the board. That defense is never going to work. That'll never get past motion practice, let alone be presented to a jury, because it's not a defense. You can't create new elements of a crime and then say they're not present. Those are not the elements of the crime, and therefore that's not a defense to the crime. The third is selective prosecution. Oh, he whines at length about selective prosecution, and all of his surrogates do too, whether they're Alina Habba or Stephen Chung, whoever that is, who tweets out things or sends things to social media. Selective prosecution, whataboutism. This is the whataboutism defense. What about Hillary's server? What about Joe Biden's garage in the Corvette? What about Pence? Everybody's doing it. Everybody's committing violations of the Espionage Act. It's my artist rendering of the whiny defense, which will never see the light of day in a courtroom and will never be presented to a jury. But I guess it makes good media, makes good sound bites for the day, and allows him to collect tens of millions of dollars from his gullible followers. But that's not a defense. First of all, it's not a defense. Even if the federal government only prosecuted him because of his own bad acts and never prosecuted anybody else, that doesn't give you selective prosecution under the law. That's one. Secondly, there wasn't selective prosecution. This is like comparing him to Hillary Clinton or Joe Biden is like comparing apples to bowling balls and chainsaws. This isn't even apple to other fruit. This is apple to something else entirely different. Hillary Clinton didn't hide her server. She didn't say, well, they're coming to Chappaqua to take the server from the basement. Let me go send it on a plane down to Little Rock and put it in my mother-in-law's trailer. I mean, that's not what happened. Okay. As soon as it became known that she was using her personal email account and had a personal server maintained by an IT guy in her basement while she was Secretary of State, she turned it over. Right? Sure, a couple of emails got lost in translation, but she didn't hide it. She didn't obfuscate. She didn't obstruct. She didn't lie to the federal government, the federal agents, the FBI, the Department of Justice, her own lawyers, people on her staff, federal judges. She didn't do that. So how is that comparable? That's like comparing somebody that's guilty of vehicular manslaughter to somebody else that's guilty at best at attempted jaywalking. Yes, it involves streets and cars, but that's all they have in common. And so take that off the board. Joe Biden having old documents that he didn't even know he had that were locked in closets that were with the University of Delaware for a future foundation of his, or in a garage, who cares? You have to have willfulness to commit a crime. This is not a regulatory administrative violation, Mr. Trump and your lawyers. This isn't a slap on the wrist. This is a crime. And in this country, under our judicial system and our system of jurisprudence, there has to be criminal intent. We call it mens rea, or willful mind. Where is the willful mind for Joe Biden? Where is the willfulness, the willful criminal intent for Hillary Clinton? But it's all over the indictment and the facts that have been developed by the Department of Justice against Joe Biden. I mean, see, now you got me doing it against Donald Trump. Sorry, followers and listeners, but you knew where that was going. So missing willfulness, you don't have a crime. Plain and simple. First day law school, criminal law 101. Must show mens rea, and that's the difference between civil law and criminal law, is the lack of mens rea, willfulness, criminal intent. All over Trump, missing from Pence, Biden, Clinton. Period. Full stop. We're done. No further comparison. Take it off the board. Now let's go to their attempts to suppress evidence. Of course, they don't like the thousands of documents, dozens of boxes, and top secret and classified information that was obtained in the search warrant. So they're going to try with Judge Cannon, or whoever the judge is going to be, to suppress the evidence, claiming that it was somehow an improper search warrant. Now, they can attack the foundation of the search warrant and try to argue that the affidavits in support of it were invalid. And therefore, the magistrate judge never should have issued the search warrant. Search warrant should never have been executed. Documents should never have been taken out of Mar-a-Lago. Suppress, suppress, suppress. In the law, we call that the fruit from the poisoned tree, the fruit from the poisonous tree. You can't eat the fruit of a poisonous tree. So if the process was tainted, you can't use the results of that process. That's the general approach. But that doesn't apply here. That magistrate, Judge Reinhardt, in listening to the evidence that was presented, had probable cause to issue that search warrant, and they were right. He was moving the documents in and out of Mar-a-Lago, within Mar-a-Lago, and hiding them, and getting dozens of people to help him do that. And that, ladies and gentlemen, is probable cause that the documents are not going to be properly maintained or retained in order to use just a regular old-fashioned subpoena process, that we got to go in and knock down the door and go grab the boxes. So he's not going to win suppression of the Mar-a-Lago execution of the search warrant, which was based primarily on witness testimony that was obtained by the Department of Justice. They're also going to try to attack Evan Corcoran, who they, oh my God, if I could think of a witness that they fear more than Evan Corcoran, I can't think of it. Evan Corcoran is not just the former lawyer, but put a pin on that. I want to talk about something on this hot take. I'm not sure he's the former lawyer for Donald Trump anymore, but it was announced that he resigned, that he at one point was a target of the criminal investigation because he ended up lying to the Department of Justice and the FBI about having done a search, which the video timer shows his entire search of dozens of boxes behind a locked door lasted less than an hour. It was like 47 minutes, and came out with, his 34 pages of documents that he said were classified, needed to be returned, ignoring the hundreds more next door in the office desk drawer, Donald Trump's own personal living quarters, and all that. A federal judge, chief judge of the Circuit Court in District of Columbia that oversees all things grand jury, already found, based on the evidence, that there was more likely than not that Donald Trump, with Evan Corcoran's help, committed a crime or fraud about those documents, and used the crime fraud exception to the general attorney-client privilege to strip the attorney-client privilege away from Donald Trump, because the client holds the privilege, and force the lawyer to testify. Not just testify, turn over 50 pages of single-space notes that he took about Donald Trump and the instructions he gave Donald Trump and the information Donald Trump communicated back to him, and an audio tape that the lawyer, Evan Corcoran, recorded as his own private musings about the case. All went to the prosecutor. Of course, they hate that. It's not just used as evidence to get the indictment. It's Evan Corcoran coming through the courthouse steps, up the courthouse steps and through the back wooden door to take the stand when the government says, "Our first witness, Your Honor, we call Evan Corcoran." That's my artist rendering of the reaction. It's going to be like that, because he's going to have to testify about all of those attorney-client deep, dark, secret relationship and communications with Donald Trump to commit crimes about the Mar-a-Lago documents. So they're really worried about that on the Trump side. So they're going to file a motion with Judge Cannon or whoever it's going to be and try to suppress Evan Corcoran from ever testifying or any of his evidence. And I have a high degree of confidence, based on knowing Judge Beryl Howell, the chief judge in the District of Columbia, who heard all the evidence, that she got it right. She got it right related to that ruling, that there was a crime fraud exception that applied, stripping it from Donald Trump. Now, the judges in the Southern District of Florida don't have to listen. It's not dispositive when judges in another place, even chief judges in another place, in this case, the District of Columbia, make a ruling about an issue. It's persuasive. The appellate court, the 11th Circuit, and the Supreme Court will certainly find it persuasive. But at the end of the day, the trial judge sitting in Southern District of Florida, her boss is not Beryl Howell sitting in the District of Columbia. Her boss is the 11th Circuit and ultimately the U.S. Supreme Court. So she could say, well, Beryl Howell screwed up here, and that should never have been allowed. And I don't find that it was a proper attorney-client privilege stripping by them, and therefore I'm going to exclude all things Evan Corcoran. Look, first, that motion's going to come. We're going to follow it here only on the MeidasTouch network, where I do my hot takes at the intersection of law and politics. I predict that's going to lose. If it doesn't lose in front of Cannon, it'll lose at the 11th Circuit and ultimately the U.S. Supreme Court. Could delay things in the trial. Some of these things are going to lead to potential delay in the trial, pushing it into early 2024 or mid 2024. But that's his last hope, that Trump is able to suppress the Mar-a-Lago search warrant results. I think that's a dead-on arrival loser, based on the evidence that I know about, and try to suppress Evan Corcoran. And knowing Judge Beryl Howell and how careful she is, I believe she got that law right. She's applying it right to the facts. And again, if Cannon screws it up, the 11th Circuit won't, which is her boss is sitting in Atlanta. And then we go on to the U.S. Supreme Court. That's the big four defenses you're going to hear over and over ad nauseum from Donald Trump. I'm almost fatigued talking about them, and it's only been a week. But that's what you're going to hear everybody trot out. And when you're debating or discussing these things with friends and family, some of which who may sit on a different political side of the spectrum than you, these are going to be their talking points. Selective prosecution, suppression, Mar-a-Lago search warrant was not properly done. Evan Corcoran should never have testified against Donald Trump. He wasn't a spy, so no Espionage Act. He gets to magically create things into personal papers that were national defense information, so no Espionage Act, no obstruction, no that. I mean, he's just going to die the death of 1,000 paper cuts. How many of these things can he explain away in front of a jury? Most of these defenses, if not all of them, will never see the inside of a courtroom to get to a jury, because they'll be destroyed before that by the Department of Justice and proper appellate rulings. We'll follow him here on the MeidasTouch network, because that's where I do my work. at the intersection of law and politics. I'm a practicing lawyer for more than 30 years, including in the Southern District of Florida, where I practiced for over 20 years. I've been before the judges we're talking about. I know how these cases are going to turn out based on my own personal experience and my own judgment. And that's what I bring to you in these kind of hot takes. If you like what I'm doing in a hot take like this one, give me a thumbs up. It helps. It helps with the quality and quantity of what we provide every day on the MeidasTouch Network. We curate the best of these analyses. We bring it to you on Wednesdays and Saturdays on a podcast called Legal AF on the MeidasTouch Network. If you like what I'm doing, I'm Michael Popok. You can follow me on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.